All right. Good afternoon, everyone. Thank you so much for being here with us. I am going to go ahead and get ready to start this. I really appreciate your patience. I wanted to give a few minutes for all of those people that were still trying to log on and get connected to the webinar to be present so we can have all of our people here and have the best turnout for this webinar. So as I adjust my camera, get everything ready. So my name is Alina Nunez, and today we're going to be discussing what happens to your property if you die without a plan. And we're going to be covering the topic of estate planning, how to best prepare, and answering some, frequently asked questions, and hopefully even getting rid of some of false information that might be out there that people have misconceptions of. So since this is a live webinar, we are hosting it now today, January 22nd. If you have any questions throughout the webinar, please put it in the chat. At the end of the chat, I'll be more than happy to go through all the questions and take care of answering them. So let's get started. All right. So as I mentioned, my name is Alina Nunez. For those of you that don't know me, maybe haven't attended any of our webinars or met with me in person, I am an estate planning and probate attorney here in South Florida. I have been an attorney for longer than I want to admit. No, I've been an attorney since 2003, so I'm going to be going on 23 years as a licensed attorney, and I have had my own practice, my own firm for the last 12 years. And as I mentioned, we do focus on real estate law, estate planning, and probate. I jokingly call myself a dirt lawyer because everything we deal with is dirt. Either real estate, you're buying it, or probate, you're buried under it. So, and believe it or not, those practice areas are all very intertwined and they relate to each other. A lot of times people ask me, well, why such different practice areas? I'm like, well, if you really think about it, what is our biggest asset that we own? Our homes, investment properties, real estate. The day we die, we have to plan to see how we leave that to our heirs, to our loved ones, to our family, children, and preserve that legacy of what we've built here. So that is what we do. And so they're very intertwined. And I am very passionate about helping people because I have very personal experience with that. My father suffered from Alzheimer's for many years before passing away. So I know the importance of planning with time, of making sure that you have everything laid out before it's too late and you can't make those decisions for yourself. So that is a little bit about me. For those of you that don't know me, welcome. It's always a pleasure. So now let's get into this and talk about what happens to your property if you die without a plan. And some people have the misconception of, well, if I die and I don't have a will or I don't have a trust, the state is going to keep everything. And that is the furthest thing from the truth. Okay. Now, what will happen is you will subject your family, your friends, your loved ones, your children to have to go through a court process called probate that can turn into months, years, unnecessary fighting, unnecessary cost, fees, expenses, and you have no control who receives what. The court does. So we have a saying, in our probate world is if you don't have a will, the court has one for you. And it might not be what you want. And that's why it's so important to make sure and that you plan ahead. Because in planning and doing your estate planning, I know it's not the topic everybody loves talking about. We're talking about dying and planning for dying and planning for worst case scenario. But you know what? It's life. It's reality. And it's going to happen. And it's best to be planned and be prepared. Because if you don't plan it, you're just one of these of, well, they can just deal with it when I'm not here. The court will be the one dealing with it. And if you wanted or intended for your assets to go to a specific person or specific individuals, and that's not what the law says, that's not what's going to happen. So there are 4 ways that you can pass on your assets or that you can make sure things are distributed. Okay. We have our last will and testaments. We have which are if you die intestacy or intestate with no will or no preparation. by designating beneficiaries on accounts and by having a trust done. Sylvia, I see it was the duration of the webinar. I try not to go past 1 o'clock, including the time for questions and answers. So we try to keep it at just an hour. So that way, if you are attending during your lunch hour, you don't go over. So hopefully you can stay. If not, once the webinar is done, everyone that registered and attended, you will get a link with a video copy of it. So the 4 ways you can pass on your assets: through a will, which does not avoid probate; through the laws of intestacy, which is what the court says or the law says who receives what if you don't prepare; by naming beneficiaries on your bank accounts; and or by having a trust ready. So what exactly is estate planning? And people think, well, estate planning is for rich people. Estate planning is for, millionaires or billionaires. I don't have an estate. Yes, you do. Yes, you do. Anything that you own is considered your estate, from your jewelry to your personal property to your car to bank accounts to real property. All of that makes up your estate. So planning and doing your estate planning is a strategic organization of all of those assets to ensure that they're managed and they're transferred to the people that you want the day you were to pass away, and hopefully avoid probate. So like I mentioned, there's a list of examples of what assets are considered part of your estate. Okay. Even furniture. So the question I get the most is, well, do I need to do a estate plan? Do I need to do a trust or a will? I don't have a lot. I just have my home and a bank account. Well, how much is your home worth? That has a value. Absolutely, you need to do an estate plan. So you need an estate plan if you own a home or any type of property, if you have children or loved ones, depending on you. You want to avoid probate and probate delays and costs associated with probate, and you want privacy and control over your wishes. Those are all wonderful reasons in which to have estate planning done. So a lot of times I tell individuals, doing your estate plan isn't always based on, well, all the amount of assets you have and having millions or having a large estate. A lot of times it's even more importantly based on, well, do you have minor children? If you were to pass away tomorrow, heaven forbid, who's going to care for those children? Who's going to be the guardian? What happens to those assets that you leave that child? You can't leave a property to a child and then they can't sign any documents regarding that. So it's not just planning for your assets, it's also planning for your family and controlling how you want your assets distributed. So here's what we call the must-have documents for estate planning. This is your basic, everyone should have this: a durable power of attorney, a healthcare designation, a living will, a last will and testament, and ideally a revocable living trust. Okay, so we're going to go through these and what each of them mean and the functions that they serve. So a durable power of attorney, or POA as we refer to it, is you are granting someone, the person you choose, the power and responsibility to make decisions on your behalf if you become incapacitated and you cannot make those decisions, or if physically you are not able to make those decisions or be able to take care of your affairs. Examples of that include, let's say you're out of the country. That's why I say physically. Let's say you're out of the country. Unfortunately, now with the state of our country and what is happening, I have a lot of clients that are concerned that they might face deportation and they have assets here in the United States. They have a property, because foreigners can buy properties in the US. So let's say they have their apartment or their property, their home where they live, and their big concern is, Alina, what happens if I get picked up by ICE and I get deported and I have this property here in the United States? I need someone to be able to manage those things for me. That's where a power of attorney comes into place. You can name someone here that can sign documents on your behalf, make decisions, maintain the property, rent it, collect rents, do whatever needs to be done as if it was you in case you cannot physically be here. The other more common use for a power of attorney is if you don't have the mental capacity. So let's say if you have a family member, a mom, a dad, as I mentioned earlier, my father suffered from Alzheimer's. So when we started realizing that, he himself told me, please prepare whatever documents are needed so that your mother can take care of things if this advances. And so with that power of attorney, once that person doesn't have the capability of making those decisions, they're still alive, you can do so with that power of attorney. And that is probably, I would say, one of the most important functions of this document, and the most commonly used by our clients, is when they're either a family member, loved one is in a state of dementia and they need to step in and make decisions. They need to sell that house, put that money into a trust for their mother or their father to be able to pay for the nursing home or the caretaker that's going to be taking care of them. So durable power of attorney, that's used while you are alive. Once you pass away, that power of attorney is done. So the benefits, as I mentioned, it avoids guardianship court, because if you do not have a power of attorney and the person is incapacitated, meaning they don't have the mental capacity to sign legal documents, and they didn't plan ahead and have a power of attorney prepared, then now you're going to have to open a guardianship case with the court, and we're going to have to appoint a legal guardian, and that case will be open until the day that the person passes away. And anytime any decision needs to be made, any monies need to be used to be paid for anything, it all has to go through the court. So now you have the court kind of acting as big brother, overseeing everything. That means time, money of costs, of incurring legal expenses and so forth unnecessarily. Where if you just did a power of attorney ahead of time, you would avoid all of that. So the other benefit allows someone to pay, manage bills and accounts immediately. Like I mentioned in the example, if you have someone that has to leave the country, and it protects your home and finances if you're incapacitated because you have someone that you have picked taking charge of what you want done. So the second document is the designation of healthcare surrogate. This is very similar to a durable power of attorney, but it's to make health decisions. Same concept. You are naming the person that you want to step in and make decisions, medical decisions on your behalf, if you cannot speak for yourself or make those decisions for yourself. So who can act as a healthcare surrogate? Any competent adult that's at least 18 years of age can serve as your healthcare surrogate. I always advise my clients in all of these documents, whether it's the power of attorney or the healthcare surrogate, name your primary person and give me an alternate, give me a backup. Because what happens if there's an emergency, heaven forbid, and you're in a car accident, you're rushed to the hospital, you're alive, but you're unconscious, you can't make decisions, and the person that you have on your healthcare surrogate is on a cruise, on vacation. If you don't have an alternate, then the decisions are left in the hands of the doctors, the hospital, or having to petition the court. So that's why it's very important to have this. And I always advise, you don't need to have it, but I always suggest to at least have a primary person and a backup person. It does not have to be a family member. It honestly can be anyone. It could be a friend. It could be anyone that you trust. That would be my suggestion. Someone that you know is going to have the same values and knows your wishes if it were ever come to a point of having to make health decisions on your behalf. And they have to be 18 years of age. So the third document is a living will. This is not our last will and testament. This is a very different document. This is called a living will. This kind of ties in and goes very hand in hand with the healthcare surrogate that we were just talking about, because it is a legal document that spells out and states your decision, your wishes regarding medical treatment that you would or would not want to have in a situation where you are in a end stage condition, in a persistent vegetative condition, where if you do not want to be maintained alive artificially because there is no solution, no coming back from that, you leave it expressly stated in this document that if it were to get to that point, your wishes are that you be allowed to die naturally. So you're taking that burden of what decision do we make? Do we leave them connected? Do we not leave them connected? What would mom want? What would dad want? You're saying, these are my wishes. Once the doctors and everyone has determined this is the condition, this is what we're dealing with, you're letting your wishes know that this is what you want them to make that decision. Because again, you are alive, but you cannot verbalize that decision. Just like the power of attorney, just like the healthcare surrogate, the living will, all three of these documents are to be used while you are alive. Once you pass, those documents are done. And then we go into the last will and testament and the revocable trust. The advantages of the living will is it clarifies your wishes for future medical care. It reduces the stress and the uncertainty on your family members of what to do, and it prevents emotional conflicts. I've seen families be torn apart where one person says, "Oh, mom would not want to be connected. This is not how she would want to live." And another one saying, "No, no, no, don't disconnect her," and there's just this internal fighting. With this document, you're letting your wishes be known, whether it is to keep you alive or not. So, our fourth document, we've talked about the ones that are useful during your lifetime. Now we're going to talk about the ones that are preparing for, heaven forbid, the day you were to pass. So we have our last will and testament, or it's also known as a will, a last will and testament. And that's the legal document that states who should receive your assets after you pass away and who is going to be the one that's going to be administering your estate, your personal representative. Who are you going to put in charge of making sure that your final wishes are carried out and that the people that you name in there receive the assets that you specified. So having a will is good. It's not the best. It's better than nothing. So if I were to rank this on worst, better, best, it would definitely be worst is having nothing. Better is having at least a will done. And best is having irrevocable trust. So a will is good because, again, it gives you control to name who you want to inherit your assets. So if you, let's say, have two children and you do not have a relationship with one of your children and it's strained and you don't want them to inherit anything, you have a right to do that so long as that child is over 18 years of age. You can absolutely disinherit that child. No child over 18 years of age has any rights to inherit under their parent. You can leave all of your millions to a charitable organization and your child can try to fight it and they will not win. They cannot come in and say, "Oh, wait a second, but I'm her daughter. I'm her daughter. How is she going to give everything to, let's say the Cancer Association? I'm her daughter." Does not matter. That is what a will does. It gives the person the right to determine who they want to receive their assets and what assets and how to distribute them. Also, if you have minor children, it's somewhere where you can name who the guardian for those minor children would be. It lets you pick who is in charge of making sure all your wishes are carried out. That is your personal representative. Again, it could be a family member or it could be someone else. In order to serve as a personal representative, you have to be 18 years of age and you cannot have committed been found guilty of having committed a felony. So long as you meet those two requirements, it could be anyone. And also it avoids Florida's default rules if you don't decide. Those default rules are called the intestacy laws. So if someone dies without a will, as I mentioned earlier, contrary to popular belief, no, the state does not keep everything. The court will distribute all your assets according to the laws of intestacy. And I describe it as kind of looking through your family tree. It's like one of these, you have like all your family members and blood relatives, okay? Non-blood relatives have no rights to inherit. So unless it's a spouse, caveat, unless it's a spouse, and unless it's a legally adopted child, okay? But let's say if you have a stepson or a stepdaughter, stepchild, they have no right to inherit unless there is a will where you are including them. But according to the laws, it's only your spouse, your children, grandchildren, parents, siblings, nieces, and nephews. And basically the law looks through and kind of does like this little puzzle and starts asking questions like those flow charts of it asks a question. If yes, go this way. If no, go that way. That's exactly what it does to determine who has a right to inherit. So it might not be the person you want to inherit. For all you know, maybe when it gets through the flow chart, maybe your brother is the one that inherits everything and you hate your brother or you hate your sister. And you're like, "No, I don't want them to inherit." Well, that's why you should have your documents done because it gives you the ability to control that. But remember, wills do not avoid probate. That's why our fifth document, a revocable living trust, is better than having just a last will and testament done. So a revocable living trust lets you transfer your assets into a trust. So you can put monies into that trust. You can put properties into that trust so that once you pass away, That trust is distributed. The assets are distributed to your beneficiaries on the conditions that you put. Everything is managed by your trustee, and it avoids probate. That's why, honestly, a revocable living trust is the best option for estate planning. So the benefits of a trust, it helps avoid probate. It's faster and it's private. When you have a will and you start a probate, that will that you did is filed with the court and it's part of the record for your estate and it's public record. I can go into any probate case online, not because I'm an attorney, if I wasn't, and I can see certain documents that get filed. And the will is one of them. A trust is completely private. No one gets to see what the trust says or who is receiving what assets from the trust. It gives you control over how and when assets are distributed. You can put certain conditions. Let's assume you're leaving money to a grandchild, and you say, okay, I'm going to leave $50,000 to my grandson. But you know what? At 18 years old, which is the legal age here in the United States, I don't think he's going to be mature enough to know what to do with that 50,000. I don't want him to just go spending it on traveling or buying expensive cars. I really want that money to go towards his education or to help him buy his first home. You can put conditions in a trust. You can state that that individual won't receive that money until they reach the age of 25 or 30 or whatever age. You can state that that money is to be used solely for his education and to achieve a bachelor's or a master's or a doctorate or whatever it is. If they don't receive the money. You can control all of that. That is the beauty and the benefits of having a trust. And sometimes that is very important to the client because they might have a situation where they do have a child or someone they're leaving assets to that maybe doesn't know how to manage their affairs, or they're very worried about that, or maybe they have an addiction problem. So they want a trustee to oversee that money to make sure that the money is used wisely. That is what a trust allows you to do. You can, the successor trustee will go ahead and manage your assets if you become incapacitated while you're alive. And also it helps avoid guardianship court involvement if you become incapacitated. So equally with the power of attorney, a trust names a successor trustee, and the assets that are in that trust, it says if during your lifetime you become incapacitated, the successor's trustee can step in and manage those assets for your benefit. So again, avoiding all that need for a guardianship and having the court always involved in your life and your affairs until the day you pass away. So what is the difference between a revocable living trust and a last will and testament? Okay, and I think, Fernando, I just saw your question. This might answer it for you. Perfect timing. So a trust can help your assets transfer privately after death, avoids probate. A will becomes part of the public record, has to go through a probate, does not avoid probate, goes through that court process, and you cannot manage affairs if you become incapacitated with a will. Okay. Now, Fernando, you asked, I'm going to address it because we are right here in this topic of if you have a trust, does it preclude you from needing a last will and testament, or is having both best? So to answer that question, once you have a trust, your trust is your primary document, right? That's what we're going to base ourselves on. We're going to transfer all our assets into our trust. But we also always prepare what we call a pour over will. It's different than a last will and testament. Basically, it acts like a backup to the trust, or like a safety net, I like to say it, where if, let's say, so you create your trust 2026, right? You come meet with me, Alina, I want to do it. Wonderful. We get your trust done. Let's say by February, your trust is done. Wonderful. Let's say in 2028, you open up a bank account and you put money into that bank account or investment account, and you did not name a beneficiary on that account. There's no beneficiary. When you die, that account will have to go through probate. So what the pour over will does is it acts like a safety net, and it tells the court, I have this bank account, or the decedent had this bank account. They forgot to name a beneficiary. So now that's part of their estate having to go through probate. But they have a trust. And this is what the trust says. So the will incorporates, the pour over will copies all the exact terms of the trust into the will. And it tells the court, I want that money to go into the trust and get distributed according to the trust. That's why it's a pour over will. It pours it into the trust. So yes, you would still, that scenario, you would still have to go through a probate, but it makes it a lot simpler and smoother, and it transfers everything to the trust. And then the probate gets closed out and you distribute everything through the trust, again, privately, nobody having to know who's receiving what. So whenever you have a trust, you always have a pour over will, but the primary document is the trust. Okay, so I hope that answered your question, Fernando. If not, I'll feel free to elaborate a little bit more at the end. So why a revocable living trust? A revocable living trust can be updated during your lifetime. It helps you avoid probate, keeps matter private, stay in control if you become incapacitated. So that's the benefit of a revocable. There are several different types of trusts. There's many, many trusts. We have charitable trusts. We have gun trusts. We have pet trusts. We have trusts that you can set up and put money into a trust if you have pets and you want someone to take care of those pets the day you die. Revocable trust gives you retain all the rights and control over your assets during your lifetime, and you can make changes to your trust. And then we have what's called an irrevocable trust. Those are used in very special, unique situations because with an irrevocable trust, once you create that trust and transfer those assets into the trust, you cannot make any changes. So there's very specific reasons why we would use those. So how does a revocable living trust avoid probate? When the assets are titled in the name of the trust, like a property. So let's say if you own a home, we create your trust. We're going to prepare a deed. And we're going to prepare a deed, transferring that property, your home, from, let's say, Alina Nunez to Alina Nunez as trustee of the Nunez Family Revocable Trust. That is how assets are transferred into the trust as far as real property. On bank accounts, you would name the trust as the beneficiary. So let's say if you have an investment account, instead of having your child as the direct beneficiary, you would name the trust. And so when you pass away, the trust receives that money and it gets distributed according to what the trust says. Okay. Probate is often avoided because the assets are owned by the trust, not in your individual name. So here's a little pie chart showing you the differences and some of the similarities, because there are some similarities between wills and trusts. So a will dictates what happens to your property when you die. Assets stay in your name. A trust, you can manage the assets during your lifetime and after death. The assets are titled to the trust together. One of the benefits they both gives, it ensures that your property gets distributed how you want. So they both accomplish that. A will, though, doesn't avoid probate. It has to go through a different process, where a trust does. So I touched upon just now, I talked a little bit about revocable and irrevocable and all these other trusts that exist. Here's a little kind of frequently asked question or a comparison of a revocable versus irrevocable. We can deep dive into this at another webinar. If you guys are interested in that, please let us know on our social media. We're always posting, asking, what do you want us to talk about? Give us ideas of what specific questions or topics you have. I would be happy if you guys are interested in doing a webinar specifically on what is a revocable versus an irrevocable trust and really get into detail with that. But here's a little kind of just a snapshot. So a revocable trust, you retain control over your assets during your lifetime. You can change the terms of that trust. So let's say if in the trust you say, I have a client of mine that he set a certain age in which his son is to receive the assets. He's come back and said, you know what? I want to increase that age. I don't feel comfortable that at that age he's going to be mature enough. Let's bring that age up. Perfectly fine. You can make those changes, or you can change the amount of the distribution. Let's say I've had clients who leave certain monies to charitable organizations, to the Humane Society, St. Jude's, Cancer Association. And let's say initially they said, I want to leave $10,000 to each organization. Later they come back and they can say, you know what? I want to leave 5, or I want to leave 20 to each. You retain those rights. And it does not give you protection from creditors. That is one big misconception. A revocable trust does not protect you against creditors. The reason why is because you retain control of the assets. It's treated as if it's you. So that's one big thing people think, oh, it's in a trust. I'm good. I'm protected. No, not a revocable trust. So an irrevocable trust, you give up control over your assets. That's a big difference with the revocable. Again, there are strategic times where an irrevocable trust is better than a revocable, but those are on a case by case situation basis. Flexibility. Once the terms of the trust are created and locked in, they cannot be changed. Okay. The benefit it does have, it will protect you from creditor and lawsuits. So, again, you really need to speak to someone who knows when an irrevocable trust is necessary or a best option for you versus a revocable trust. Fortunately, you can't have your cake and eat it too. So let's go a little bit real quick. We're already at 12:37 through some estate planning myths and facts. Myth: I don't need an estate plan if I am young and healthy. Well, an estate plan is crucial at any age to prepare for unforeseen events and avoid complications. So remember, when we discuss estate planning, we're not just talking about the day you die. We're also talking about when you are alive, if something presents itself and you cannot make decisions for yourself. One big example that I give regarding this, and I've hosted many webinars on this, and parents practically have a heart attack when they realize this, is as soon as your child turns 18 years of age, and I have an 18-year-old son, they are considered a legal adult. And I have absolutely no rights to make any medical decisions on his behalf. I have no rights to access any of his medical records. I have rights to nothing. Now that's scary because I know my 18-year-old, and you know, might not be the most mature and still relies on mom, what do I do about this? Mom, what do I do about that? So it is extremely important if you have children that are approaching 18, are 18, are on their way to college, that you have them do their estate planning. You have them prepare a healthcare surrogate, a power of attorney, because if something were to happen to them, and in one of our webinars, the one that was specifically asked to this topic, I addressed a situation that happened with a student about 2 years ago, where she was coming back for her second year at She's originally from Rhode Island, I believe. I know she was up north. I believe it was Rhode Island. And right before classes were to start, the second semester, she was pre-med. Her and her friends went out to party, kind of celebrate, the last hurrah before starting school, starting the semester. She ended up in an Uber with people that she did not know. Something was slipped in her drink, and the Uber driver left her in the middle of the street in a neighborhood. She had no idea, and she was drugged. She walked out into traffic, and she was hit by a car. She ended up in the hospital in a coma. They called her mother. And the first question the hospital asked is, do you have, or does your daughter have a healthcare surrogate, a designation of healthcare surrogate? And the mom said no. And they said, well, we cannot give you any information, but you need to get down to Miami immediately. The toughest part is the mother was a nurse in her state. She came down here. She could not make a single decision on behalf of her daughter. She could not find out any information whatsoever. All she could do was sit there and be by her side while the doctors and the hospital made all the decisions. And ultimately, her daughter passed away. So, not to scare you guys, but that is reality. That is life, especially when it comes to our children. Once they turn 18, they need to have these documents in place. And ever since I've done these webinars and put that out there and basically informed parents of this, I have prepared, I've had the pleasure and the honor of preparing several estate plans for my son's friends, schoolmates, childhood friends that are now 18 years going off to college, so that their parents have peace of mind that if heaven forbid anything were to happen, they do have those documents in place. So age does not matter. Myth: if something happens to me, my parents' spouse can automatically make medical decisions. This goes exactly to what I was just saying. The fact is, if you are over 18, no one, no one, not a parent, not a child, not a sibling, anyone can legally access your medical information or make medical decisions without a written document. Another prime example of this for all of you that maybe are a little older, my generation, and here native Floridians, if you remember the case of Terry Schiavo back in the day, she was 26. She lived up in northern Florida. I don't know if it was like Tampa, Jacksonville area. At 26, she had a heart attack. She did not die, but she had brain damage due to the lack of oxygen. She was a vegetable and she did not have any documents in place. And her husband and her parents spent years, years. I want to say, I think it was 15 years fighting over who had the right to make the decision whether to keep her connected or not. It went all the way up to the Supreme Court of Florida. And beyond that, it went up to the Supreme Court of the United States, where they finally gave the decision to the husband. And once he disconnected her, she passed because she was a vegetable. But for 15 years, this husband could not move on with his life. These parents could not move on and grieve the loss of their daughter and were suffering in legal battles, fighting in court, spending thousands of dollars. Myth: any property I owned before getting married will automatically go to my kids if I die. Oof, this is a big one. And we have faced this many times. And the fact is, no. If in Florida, your spouse has automatic inheritance rights, even over property that you owned before marriage, unless you have proper estate planning or prenuptial agreement where the spouse has signed off on those rights. Without one, they are entitled to inherit, and your kids will not inherit 100%. Your kids will inherit, but they'll have to share it with that spouse. So if you're adamant that your property, your assets that you owned before you got remarried, we're talking about here like a blended family, right? A second marriage or a third, you need to either have a prenuptial agreement before you get married, or if you didn't, then you need to have proper estate planning where that spouse signs off on waivers and rights of that asset so that you can leave it to your child. Because even if you leave it written in a will, that will be determined void because it violates Florida law. So please, that's a huge one. And I've had to litigate probates like that. And it's really sad because the person that passed away thought they were doing the right thing by getting a will done. Oftentimes they do those wills with non-attorneys. They go to a notary or they Google it themselves or chat GPT it. And I hate to say it, people, but we are attorneys. I suffered through law school and 23 years of experience to do what I do and know what I know. And that is what you get. You get the knowledge that comes with specializing this and knowing what to do. So the next myth: if I die without a will, my family will just divide everything fairly. Oh my God, famous last words. The fact is, no. If you die without a will, Florida law, not your family, is going to decide who gets what. And the distribution might be very different from what you had planned. Maybe you thought, oh, my spouse is going to get everything. And that's what you would want. But if you are in a blended family and you have children from a different relationship, then no, the spouse is not going to get everything. Your children will get a portion. So it's very important that you plan and leave everything in writing and inform yourself correctly of what can and cannot be done. Myth: probate is quick and simple in Florida. No, anything that involves the court, lawyers, anything like that is never quick and simple. Sorry. So a probate process can take anywhere from 6 months to 18 months or even more. I currently have a probate case that's over 2 years because we're litigating and we're fighting. It can cost thousands of dollars if people are fighting and you want to avoid it. So in order to avoid it, you need to plan and do a trust and have everything done. So I wanted to throw in one little example of a famous person that unfortunately didn't do proper estate planning. And you would think with the millions that Prince had, I'm sure he had everything in order. No, he didn't. So Prince, the amazing musician and artist, passed away unexpectedly in 2016. He was just 57 years old. I'm sure he didn't expect to pass away. And he left a valuable estate that not only included real estate, personal assets, but included licensing rights, major music rights, his catalog, everything. He died without a will, so he left no written instructions on who should inherit from his estate or who would be in charge of administering everything. But because there was no plan, so then it has to go through probate, and that's when everybody starts fighting. And everyone starts, trying to see what they're going to get, what they're entitled to, and take control of everything. So basically, the court ultimately recognized his sister Tyka Nelson and his half sibling Sharon Nelson, Noreen Nelson, John Nelson, Alfred Jackson, and Omar Baker as his heirs. And then it became a long legal battle because now you have a full sibling fighting with half siblings over millions that this superstar had. So this is a well-known example of how dying without an estate plan can lead to years of delays, legal dispute, costs. I'm sure probably even his catalog of music landing in the hands of someone he probably would have never left it to. So this is a prime example of why planning is so crucial and will avoid all those issues. So it's 12:47. We have about 10 minutes, 12 minutes left to take questions and answers. And I'll get you guys out of here right at 1 o'clock. So I am going to go back and I'm going to see through the chat some of the questions I might not have answered. So Fernando, I think I answered your trust question and the will, if you need both or not. Sylvia, what are the responsibilities, duties of the trustee? That's a great question. So your trustee is basically there to distribute the assets or manage your assets as it is written in the trust. So this is the person that is going to be in charge of, once you pass away, gathering all of your assets. So if, let's say, there's a bank account where the trust is the beneficiary, they're going to reach out to that bank and say, hey, Wells Fargo, Chase, Sylvia passed away. I am the trustee of her trust. The trust is the beneficiary on this bank account. I need you to give me that money. And they're going to, what we'd say, gather all the assets. Let's say you have a house. If in the trust it says that that house, your children can live in it or whatever, great. If it says, they can sell it, then maybe they want to sell it. They sell the house and you gather all of those assets. And then your trustee is going to look at that trust and say, okay, who receives what? So if in your trust you say, my grandson gets $10,000 into a trust and he can get it at the age of 21, then the trustee's job is to go, okay, who's the grandson? Are you 21 yet? Yes, you are 21. Wonderful. Here's a check for $10,000. You got your money. You're on your way. If he's not, then they would open up a trust for that grandchild, put that money in there until they reach 21. So that is the trustee's responsibility. So it's a big job. It's a big job. It's an important job. You want to pick someone, obviously, that is trustworthy, possibly even good with managing money. So because if you are going to have them managing money for minor children, you're going to want them to invest it in a money market account or a high yield savings or a CD, so that it doesn't just sit there in a bank account earning 1%. So it's someone that you really trust and is going to be responsible enough to take on those responsibilities and role. So, Mikhail, could you add your child's name on your house and leave the bank accounts with a beneficiary? You do not want to add your child's name to your house. No, absolutely not. And especially not if they're a minor. That is like an absolutely no. But if they are adults, you don't want to add them for many, many reasons. One, the minute you add that child to that house, any judgments or issues that child might have against them, people that might sue them for a credit card, they get into a car accident or whatever, now that judgment, they can go after that house because they're an owner of the house. That's number one. Number two, so as they're a co-owner with you, they have any decisions that are made regarding that house, whether to sell it, refinance it, rent it, or whatever, they have a say in it. And I have seen families where they've added a child, then the relationship sours, and now the parent wants to sell the house, and the child says, absolutely not, refuses to sell it. Then you have to find yourself suing your child and doing what we call as a partition action. So that's another reason. Number three, when you inherit in the state of Florida, there is no inheritance tax. It's at a federal level, right? And With properties, we have what's called the step up basis. Feel free to Google it. It's a tax savings on properties that you inherit. So let's assume you bought your property in the year 2000 and we are in 2026 and you pass away and you leave that property by way of a trust, or we can also do an enhanced life estate deed. That's a whole different webinar. It passes through to your child. All that equity that you have built in that property from 2000 to 2026, that is free. That is free to your child. They pay no taxes on it, nothing. That is a gift. Now, when they inherit that house in 2026, if they decide to keep it as an investment property, and let's say they sell it in 10 years, they'll have to pay capital gains taxes on the value from when they inherited it to the day they sell it. But that's because it's an investment. If you add your child to the title, you destroy that step up tax credit. You eliminate it and they don't get that. So, no, you should never, if the sole purpose of adding your child to title is because you want to avoid probate or something happens to you, that is the worst decision you can do. Come and talk to an estate planning attorney, and we'll give you many other options that are much better in accomplishing that. Okay, so can you provide some high-level examples of situations where an irrevocable trust would be used? Absolutely, JD. So some of the situations we would use, and the most common is for Medicaid planning or for elder planning. So if you know that a parent or a person is going to need to go into a nursing home, apply for Medicaid, anything like that, and they do have some assets, they might just be disqualified from qualifying for Medicaid. So you would put those assets into an irrevocable trust so that you're managing the asset for that parent for their benefit during their lifetime. But because that parent has no control over those assets, because it's an irrevocable trust, it doesn't count against them for Medicaid purposes. Another good example is if you do have creditor protection concerns. If you feel that you're going to be sued, or there's a possibility, or if you're in a very high liability type of industry and you want to protect yourself, then you can put investment properties, for example, into an irrevocable trust. You gotta be careful because you lose control over that asset. So you can't be named the trustee. You have to name someone else as the trustee, and that is the person that manages those assets. So there are situations in which, yes, irrevocable trusts are great, but you have to be very careful, make sure it's the right reasons in which you are setting it up. Okay. Next question, Sylvia, is it important for your adult children to do a healthcare surrogate? Yes, absolutely, 100% yes. The minute your child turns 18, they should have their healthcare surrogate power of attorneys done in case something were to happen. Even if they have no assets, let's say they don't own a property, they don't own anything, you still should have the healthcare surrogate and a power of attorney to be able to make decisions on their behalf. Oh, you read about that? Yes, yes, in South Florida, Terry Show. Yep. Sylvia, what if the wife inherited property from her family while being married? Does property automatically become part of the marriage assets? That's a great question, Sylvia. And the answer there is it depends. So if it's an inherited property, it does not become part of, and you're already married, so you inherit something from your parents, so long as you keep it absolutely separate from marital assets, then no, if you were to get divorced, your spouse would not have a right to those assets. What do I mean by that? Let's say you get money, you open up a money market account or something, and you kind of leave that money there, you don't touch it. That's the easiest way to keep it separate. That's protected. Let's say you receive a property. Your parents leave you a property and you want to keep it as an investment property, right? The investment property, all of a sudden, oh man, we got to change the air conditioner unit on it. The AC broke on the investment property, and you don't have enough money from the rents in the savings to cushion to pay for that. So you take money from your joint account with your husband to pay for the air conditioner at the investment property. You're commingling. You're opening up the door now so that your husband can say, wait, marital assets, aka money from my bank account, were used to pay for that property. That is a situation which you're opening up the door now. So it's very important to keep that very separate. You treat it like a business. Put it in a corporation or put it in a land trust. Open up a bank account. All rent money is going to there. All expenses get paid out of there. Don't commingle it. Just like if you get money from your parents and you decide, oh, let's go to Europe and I'm going to take $10,000 from my parents' money so we can go travel. You're opening up the door because now you're using that money for the marriage. Okay, so those are examples of where commingling. Another example is, which is a common one. Let's say your parents leave you a home and you decide once they pass away, well, we're going to move into their home because their home is nicer, it's bigger, great. Even though the home is only in your name now because your parents left it to you, it has now become the homestead of the marriage. And your spouse will definitely have rights. So those are all important examples. Ways to go around that and avoid that, again, is you can do waivers. You can do post-nuptial agreements in order to protect those assets, okay? What else? Is there a way to convert a revocable trust to an irrevocable trust as we get older? Well, once you pass away, a revocable trust automatically becomes irrevocable. Nobody can make changes to it. Okay, so if you have a revocable trust during your lifetime, you retain control and ownership rights of that trust. The minute you die, that trust becomes irrevocable. Nobody can make changes. The trustee's job is just to make those distributions. Now, if let's say you have to go into like the situation I talked about with Medicaid or nursing home or any type of asset, then yes, we can basically, what we can do is we can dissolve that revocable trust and create an irrevocable trust and transfer the assets into that irrevocable trust when the time comes. You can have more than one trust at any given time. So it's not like you're just limited to one trust. You can have different trusts. In fact, I can set up a trust where I create a trust with me and one of my children. I create a trust with another child for certain assets and things like that. Okay. What else? Is there a way? Okay. No worries, Sylvia. You mentioned capital gains. Can you go over that again? Will I have to pay capital gains if I sell inherited property? Okay. So the way it works, again, I'm not giving tax advice. Please speak to your CPA. But so I always advise my clients who inherit property from their parents. The moment that you inherit the property, you should do an appraisal if it's real property, right? And you're going to keep it. Just say you're going to keep the property. You're going to keep it as an investment property. Do an appraisal at the time that you inherit it, the time your parent dies. That way you have like a time stamp of what that property is worth. Okay. So for example, again, I'm just going to use personal experience. My mom passed away in 2023. She left the property. We did an appraisal of that property. Fast forward a few years later, we're going to sell that property. I can then use, this is what it was worth when I inherited it. This is how much I sold it for. So that way, when I do my taxes, my accountant can determine if there is any capital gains. There might be a loss, or there might be expenses that I incurred throughout the years of ownership that I can offset any capital gains taxes. So you would be subject to capital gains taxes from the value of the moment you inherit the property to the day you eventually sell it. Okay. So it all depends on how long. Now, if it's one of those situations where you inherit the property and you go, you know what? I don't want the house. Maybe you don't live here. Maybe you live in Texas and the house is here in Florida. You're like, I don't want to deal with that headache. So you inherit it, you sell it immediately, and you get your money. You won't have capital gains on that because it was like an immediate sale. It's only if you hold on to a property longer. Okay. Can you create a trust and make your child in charge of it? Yes, you can. You can absolutely name your child as the trustee of your trust. Again, it all depends on the family dynamics, the reasons why. As I mentioned at the very beginning of the webinar, oftentimes estate planning is not so much just only the assets, it's also the family dynamics, and that part is a lot more important at times. All right, Hector, should a land trust be created as the holder of real estate asset as an added layer of protection against any liability? If it's an investment property, yes. If it's an investment property, I definitely would suggest either put it in a corporate entity that will help shield against liability, or you can also put it into a land trust and that will also help with liability. Or you can also put it into an irrevocable trust, but then there you have to be careful because you lose control over the management of the asset, unless it's a situation where, like, say, for example, you're gifting or that property is for someone else, you put it into an irrevocable trust, they're the beneficiary, but you're still the trustee. So again, this is all things that you would sit down and speak to the attorney and come up with the best strategy for your situation. And our last question, because it's 101, I promised to get you out by one. Capital gains are on federal tax returns, right? Yes, they are, Sylvia. You would pay that as part of your tax returns. And again, there's things that can offset that tax amount. But again, talk to your CPA. I do not give tax advice. So I hope I answered all of your questions. I hope you guys really found this webinar useful. If so, please let us know. Comment on social media. Follow us on Instagram, on YouTube, on TikTok. Let us know if you found this useful, and let us know any future topics you want us to talk about. I've done webinars on the importance of having documents for your young adults. I've done webinars on talking about enhanced life estate deeds and everything. So please, any topic that you are interested in, let us know. We'll put a webinar together and we'll put it out. So have a wonderful rest of your afternoon. Hope you enjoyed it. Thank you, everyone. And until the next time.